Today I'll be focusing on the Eighth Amendment, which reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted." Included in the duration of this video, I will provide information that will shed some light on the history, the present, the effects, and the application of this amendment. Some useful questions to have in mind are, what is the background and history of the amendment? What are the effects of the amendment today? What are some important cases surrounding the amendment and things of that nature? So as far as the history goes, let's begin with the history of the Eighth Amendment. The Eighth Amendment found its origin on the Bill of Rights in the year 1971. However, it originated far earlier in England. The concept of the amendment was taken from the English Bill of Rights, created by Parliament in 1689, and the wording was derived from an English treatise from the 1760s known as Commentaries on the Laws of England by William Blackstone. Aware of the injustices that the cruel and unusual practices imparted upon criminals by the legal system had, England made these changes, and the budding American government took notice years later. Seeing as the then infantile American democracy was all about restricting the government from having overbearing power, important figures in the forming of our nation, such as George Mason, adamantly proposed this addition to the Constitution because of its effectiveness in preventing the abuse of power by the government in the form of cruel and unusual punishment. As a result, James Madison proposed the Eighth Amendment to Congress in 1789 before it finally became part of the Bill of Rights in 1791. Now that you have some background on the amendment and its history, I will now focus on some main issues in debates related to the Eighth Amendment. The main conflict associated with the Eighth Amendment arises from its ambiguous language. The amendment refrains from specifying what is constituted as cruel or unusual punishment, leaving room for the legal system or the government to decide what is cruel or unusual for themselves. A specific sticking point among debaters is the death penalty, and whether or not the death penalty is technically cruel and unusual punishment. In the United States, capital punishment was not uncommon until the execution drought of 1967 and 1977. During that period, executions no longer occurred. This drought was spurred on by the capital punishment statutes put into place in 1972 after the Furman v. Georgia case of 1972, in which it was decided that all death sentences around the country be reduced to life imprisonment sentences. After the reinstatement of the capital punishment in 1976, it became and remains a situation where the answer has been decided on a state-by-state basis, with some states still practicing sentencing prisoners to death, while others abolish the death penalty altogether. Another common dispute related to the Eighth Amendment and the concept of cruel and unusual punishment is disproportionate sentencing. As a part of our legal system, it is the prosecution's burden to prove guilt without a reasonable doubt, and subsequent to the defendant being found guilty, the judge can determine sentencing based on a number of factors, but primarily their own judgment. The problem arises when deciding what punishment fit crimes based on severity and other contributing factors, and whether or not certain punishments are excessive in relation to the crime. An important Supreme Court case that interpreted the disproportionality factor as it relates to the Eighth Amendment was the Harleman v. Michigan case in 1991, where the petitioner had been, or the person who felt they were wronged, had been convicted in court of being in possession of 672 grams of cocaine, which is a lot, and subsequently being sentenced to life in prison without possibility of parole. On his behalf, it was argued that his sentencing and punishment handed down to him was unconstitutional on the grounds that the punishment did not fit the crime, and that due to mandatory minimums established under George H. Bush, or H.W. Bush administration, judges were forced into giving prisoners more severe sentences instead of allowing the judge to do their job and consider the circumstances when it specifically comes to the crime and then making their ruling. The Supreme Court ultimately ruled in his favor, and the Supreme Court Justices Kennedy, O'Connor, and Souter acknowledged that the interpretation when they said cruel and unusual punishment clause, they're referring to the clause inside of the Bill of Rights, encompasses a narrow proportionality principle. So basically they're agreeing with the fact that it's also cruel and unusual to have longer sentences, I guess. This is just one case among many others that have had the Supreme Court re-examine the Eighth Amendment. To name a few others, there was Francis v. Russ-Weber in 1947, Ingram v. Wright in 1977, Hudson v. McMillan in 1992, and Roper v. Simmons in 2005. The Eighth Amendment continues to be a point of debate in our society and continues to protect citizens of the United States, making it very relevant in the present. Just as much as it was when it was integrated into the Bill of Rights in 1791, nearly fresh off our independence. So, in conclusion, the Eighth Amendment is surely an important part of forming the essential rights that Americans have, and this importance only continues today, still firmly protecting the people and prisoners from the legal system and the abuse of the government and unfair treatment. I hope that my presentation has answered some of your lingering questions about the Eighth Amendment and that you leave more informed about the history and the relevance of this amendment. Thank you very much.